So what happens in Minnesota if you die without an estate plan? The legal term we use is called intestate. And what that means is that you're going to leave it up to your local probate court to decide what happens to your assets and your legacy with your family. For some people, this may be okay. Maybe they don't have a lot of assets, or maybe they're an only child and they don't have any family to inherit. But for many people, especially those with young children, it's incredibly important that we have the will in place. We have an estate plan to protect you and your legacy from the local probate court judge just deciding what's going to happen to your assets and how they're going to be distributed. So if we're in Minnesota and you're dying without a will, we have to look at how are your assets actually going to be distributed. Let's look at real case scenarios. So if you're married and you don't have any children, you'll probably guess what happens. Your spouse gets your entire estate. But what about if you're married with children and you and your spouse have children together? Well, your spouse gets the first $225,000 and half of the remaining balance of your estate, and then your children inherit the other half. Once again, this doesn't seem like it's that big a deal. However, many people would prefer their spouse just inherit it all, and then we go from there because they would take care of your children. Now, let's say you have children from a prior relationship, so your spouse still inherits that $225,000 and then half of the remaining balance, and your children from the other relationships still inherit the remaining portion. So if you really wanted your spouse to get it all, but you had children from a prior relationship, without a will, they're going to have to share it with your children from the prior relationship. And depending upon what your family dynamics look like, that may not be the distribution you're looking for. And then finally, if you have no spouse and you have no children, then what are we going to do? Then we have to start with the family tree. So in this situation, the probate court then has to literally put together a family tree and figure out which members of your family are still alive. We go up to your parents first, and then we go out to their siblings, and we go down. And there's a whole process that the court has to go through to determine if you've passed away and you don't have any living family members, or you don't have a spouse and you don't have children. We have to then put together this family tree and try to figure out who is next. Now, if you have children from a prior relationship, or you have stepchildren, you have unmarried partners, we have court involvement, there's a lot of different complications that we can end up with that do not have to take place. All you need is a will to specify what happens, who's the guardian for your children, how you want your assets to be divided. If you want to do unequal inheritances for your children, we want to have that in a will. Your will allows you to tailor the inheritance to your actual family situation, and not just a drawing of a family tree and then trying to figure out who gets what and equally dividing everything. Now, one of the biggest things we run into when we're looking at this situation is, what does the probate process look like? So if you listen to podcasts and if you read blogs, everyone tells you you have to avoid the probate process. I'll give you an unpopular opinion here in Minnesota. The probate process in Minnesota is actually not that tough compared to some other states. I practice in other states, and I will tell you that Minnesota is a streamlined process that does not have to be intimidating. So we're going to look at the quick overview of what the process looks like, and maybe you'll find it's not as intimidating as you think. First thing the court has to do is appoint a personal representative. That personal representative is the person who's going to administer your estate. You're going to divide the assets. They will get your children to the guardian if one is assigned. And when we're looking at your personal representative, if you didn't have a will, then the court has to figure out who's the most appropriate person to be your personal representative. However, if you have a will, you can say, I want my spouse. And if not my spouse, I want my eldest child, or whoever, maybe your brother, maybe your sister, maybe a cousin, somebody who's good with handling the issues of the court. Maybe you have a lawyer for a cousin who'd be the perfect personal representative because he practices probate law. The next step in the process, we have to create an inventory of the assets. We've got to figure out what you had at the time of your death and figure out where it's going to go. So we've appointed the personal representative. Now we're going to figure out what's in your estate. Third step in the process, we have to settle your debts. You would be amazed what happens after someone passes away, and all these creditors that nobody else in the family knew about pop up with these little things. Maybe it's an old phone bill from 1998. Maybe it's an old tax debt from a year. Or maybe it's some unclaimed money with the state of Minnesota. There can be a variety of ways that creditors can pop up when somebody passes away. So once we've appointed the personal representative, we've inventoried the assets, we've taken care of the debts, the last thing to do is we distribute the assets. So what's ever left after we went through this process, we distribute the assets to whoever is entitled. If you don't have a will, then you're looking at the probate court doing a formal proceeding and having to go through the steps I just mentioned. And so let's look at some risks that run into it as well. So first of all, you're losing all your control. So if you don't do a will, then you have no control over what happens to your estate after you're gone. It's going to go through probate court, and the judge is going to determine who gets what. And in many cases, like I said, if you're married and don't have kids, your spouse will likely inherit, and you may say, you know what, that's not the worst thing, that's what I want to have happen. But as your family grows or as other things happen, especially if like a sibling passes away who would have inherited, you've lost the control to make sure you provide for your nieces and nephews under a will. The other thing that can happen is we can have family disputes. So if somebody passes away and now the family has to go through a formal probate proceeding and people start fighting over who's entitled to what, if you have a will, you can spell out who's getting what. And if you're actually leaving a child out, you can spell out in the will why they're being left out to hopefully avoid any family disputes. They may still feel put out, but at least the family will know why they were cut out of the will. It'd be a financial burden as well by having to go through probate court. There are filing fees, so we have to file the petition. You're going to have to pay to have a notice published in the paper. You may have to deal with creditors. You may have to take some time. You may have to go to court a few times. And if you hire an attorney, someone's got to pay that attorney. So that is one of the big risks of probate court is there's a lot of fees that can start to add up that your family wasn't necessarily anticipating having to pay. And then the most important risk you're running is if you have children under 18, you're having no say in what happens to them after you're gone. So you may have a brother-in-law and your wife may have a sister-in-law, and you both agree that your sister-in-law is the best person in the world to take care of your child who's under the age of 18, but by not having a will, that's not guaranteed. The judge has to decide which one of them is the better person to be the guardian for your children. Now, the guardian will also be receiving the money from your estate as well. And so what if the brother-in-law, who's not good with children, just could really use the extra money? So they're going to put on that nice suit and tie. They're going to show up in court. They're going to tell that judge what a great guardian they would be for your children. But really all they're doing is they're in it for the money, when your sister-in-law would be the perfect guardian for them. Which is why you want to make sure if you have children under 18 that you have a will in place. You do not want to leave this process up to your local probate judge. Hopefully you've seen a little bit about the probate process and what happens if you pass away in Minnesota without a will. If you have more questions, you'd like to set up a phone call to learn more, you can go to my website, 𝙃𝙀𝙍𝙀.com. There's a red legal strategy session button on the front page. Click that and you'll be taken to my calendar. We can set up a 15 or 20 minute free legal strategy session to discuss where you are in the process and what steps you may need to take, especially if you don't have an estate plan yet and you have children under 18. We want to make sure we're getting this process rolling. If you like this video, you can hit the like or thumbs up button below. You can head on over to YouTube and subscribe for future episodes. And this is not something that I can ever really recommend to people to just ignore an estate plan and let the probate court decide. Especially if you have children under 18, get that estate plan, get it put together. You want to make sure you are appointing the right person to be the guardian of your children.